I'm not going to do roll call. I can see that we have quorum here, and that's good.
Excellent. All right. So on our agenda, we have agenda review and approving of the July meeting minutes. So unless there are any changes requested or any objections, we can consider those approved and move forward. Yeah.
Any objections to the approval of the July minutes? Hearing none, they are approved by consent.
Excellent. Okay, so then, I mean, honestly, now I just get to hand it over to Rowan, who can talk us through all of these good updates.
Great. Yeah. So just again, thanks everyone for being here this morning. I really appreciate seeing you all. I hope you've had a good summer. I'm going to just start off by letting you know that the commission, the full commission, approved the survey for distribution. The survey and the implementation guide were distributed on August 28th, 2025, which starts the clock for the schools. The schools have to issue the survey for the first time by August 28th, 2027. And you all also have to come up with or have to release another base survey by August 28th, 2027. So it can be the same survey, but what I'm hoping is that we will hear back from students and from institutions about ways to streamline the questions and make them more useful for everyone. So I'm sure we'll get some feedback on that. But yeah, but no rush on that. We've got some time. There are 2 info sessions coming up that I'm going to do just a kind of a brief PowerPoint to go over the timelines with folks, because there seems to be folks still want a little bit more clarity on that. Those info sessions are on October 6th and October 7th at 1 p.m. They will be recorded. If anyone wants to attend one of those sessions, just please send me or Kevin an email and we will add you to the sessions. You don't have to attend. If you think you might be able to, just go ahead and you want to sign up for them, that's fine. Then
what time? Sorry, Rowan, what time are those again? You said October 6th and 7th at what time?
They're both at 1 o'clock.
Okay, thank you.
Okay, sure. Yeah. I'm going to go a little bit out of order since we're talking about the survey and just give you, I haven't had much feedback from the institutions. I'm expecting to hear from them at those info sessions. Mostly the questions have been about scheduling. People just kind of confirming, wait, how long do I have to implement this? So reminding them that they have up to 2 years. We had one school that wanted to get started really early, like within the next month or so. But I'm encouraging folks to go back and review the implementation guide and work on, if they haven't already done the work of messaging on their campuses, to take a look at that, because I feel like that's really important. Yeah, so for rulemaking, so the legislation gets passed and then HEC has to implement the legislation, and there are a lot of ways that could be done. So we're kind of codifying, okay, when we see the law, what we're going to do is write some rules about how we want you to implement it. Sorry, I'm going to try and follow along in the chat right here. Okay, got it. We've kind of gone over that. So the first set of rules that we have submitted are currently open for public comment, and the closing date for those rules is the 25th. I'm going to go ahead and put a link in the chat just for anyone who's curious about seeing what kind of rules are currently pending. Or if you want to get a comment in real quick, just get it into us by tomorrow. We haven't had any comments that I'm aware of yet, so folks seem to be pretty okay with what we've presented. What I'm asking you all to look at this morning is a different set of rules. These are rules that initial rules for the survey. So I was hoping that we might, in terms of just when we want to get the rules out, there were a couple of things that I felt were really important for the schools to be looking at this fall. We will probably amend these rules or add to them as we get more feedback from the schools about how they're implementing the survey. But I'm going to go ahead and share screen and show you you have the link to the document, but I'm going to share screen and show you a version that has a couple of minor edits. I can't leave anything alone, as you all know. There we go. Here we are. All right. So the reason that we're asking you to review the rules is just because you as folks who are most comfortable with the survey. You've spent more time with the survey than anybody. I felt it would be helpful to have some input from you. So we added a few definitions about what we mean by anonymized information, completion rate, de-identified information, et cetera. Those definitions in the other document that was part of the meeting materials, I had put together references and sources for where I got those definitions. If folks have other suggestions for definitions, that would be really helpful, or if there's any clarity that they need. The one thing that I changed in the definitions, looking at personally identifiable information, I realized that I had included the indirect identifiers that are required. Many of those that are listed were required by the survey. So we can't tell schools not to collect that information. Obviously, it's part of the survey. So I just, I made that edit. So I changed it to indirect identifiers that may be combined to identify an individual. And then when I referred back to that, for example, in number 4, the online platform used to collect survey data shall not collect IP addresses or other information that could be used to identify a respondent or any personally identifiable information other than what is required to be included in the sexual misconduct survey. So I changed that. So we don't want them to use personally identifiable information like what dorm do you reside in, or what is you. I think we want to be careful at allowing questions to be added that would allow folks to be identified. The resource document that I provided you with refers to some of the things that can happen when those micro data sets, so a set of information, if one person completes the survey, that's a micro data set, and the demographics within that survey data can be used to kind of whittle down who that person might be in some cases. So we wanted to be really careful about making sure that as much as possible, we're removing opportunities for someone to take a look at the information set and be able to pretty closely figure out who someone might be. Okay. So trying to figure out how to write that into rules that can be followed legally it was a little bit of a challenge. So that's what this is basically about. So the rules that we're asking for folks to do are to not collect that identifiable information other than what they're required to, giving us when they they have to submit a report of the results of the survey after they've administered the survey. And we want to make sure that the information they give us is aggregated and de-identified. So any information that could be used to re-identify someone would be removed. So that's where we get into that aggregated set where we're talking about combining responses. And then we tried to figure out there's one institution that's already contacted us that wants to mount the survey themselves in Qualtrics rather than use the version that HEC is providing. And that's absolutely okay. They can use any platform that they want. They can mount the survey themselves. But we want to make sure that they are following the way that we've written it. We don't want them to put the questions out of order, and we want to make sure that all of the responses and skip patterns are followed so that all of the students in the state are seeing the same survey, even if it's on a different platform. I hope that makes sense. Okay, I'm going to stop talking for a minute and let you all, if anyone has any questions or comments.
Do we have to allow that? like this survey is so complicated that I mean, I'm of two minds here. Ultimately, whatever. But from a survey design and execution point of view, like it is just so complicated that I'm deeply skeptical about anybody's ability to actually reproduce it 100% on their own.
Yeah, unfortunately, well, I'm not going to say unfortunately, but short answer is no, we can't require them to use ours. They do have the right to use any platform that they want, and they do have the right to re-enter the survey in a way that they want to. They just need to make sure that the questions are exactly the same.
Okay.
And yeah, and the other thing that I realized is that I don't have a mechanism for reviewing the survey. Like if they enter it themselves, I can't say, okay, now you have to let me see your survey so that I can make sure that it matches. That we're going to have to assume that, with good faith that they will follow that. So that's just,
I totally get that. I would argue even more vociferously that you should never have to check anybody's work that way. That's just that would be an absurd ask.
Yeah.
I just if somebody doesn't, if some institution doesn't want to use this is going out as Qualtrics and SurveyMonkey, right? Like
Right.
a few months removed, and I'm forgetting the details already. Hopefully schools will recognize that SurveyMonkey, once every 2 years is just not that expensive, and it's probably way more efficient than doing it themselves. But nonetheless, I just don't see how they could reproduce it accurately. But
Yeah.
anyway, I'll stop. I'm just making you all listen to my doubts here. That's fine.
That's okay. That's okay. That's exactly the kind of feedback that I think is really helpful for folks to hear. Like, why would there be a concern there? Yeah. Yeah.
I'm
Mhm.
wondering when we are redrafting or going back to the group with the new version in a couple of years, are these things that we can think through and maybe propose ways that we could review schools' surveys?
We would need to make there would need to be a change we can't make it. There would need to be a change to the legislation to permit HEC to do that. I mean, I can make the request. I can say, I'd love to look at your survey. Will you let me look at it? But if the school says, no, we don't think that's necessary, then that's that kind of.
Right. Yes, I share Kelly's concerns, although my concerns are less around the technical ability to reproduce the survey and more around the concerns that we talked about as far as language of the survey and whether schools are going to feel comfortable with that, and if they don't feel comfortable with that and they can change it. It's a hard one, but it sounds like it's one that we just need to swallow.
Yeah, well, they're required to use the base survey as we provide it to them, but I don't have a mechanism that allows me to require them to let me take a look at it. Does that make sense? Okay.
It does. Yeah. It
Yeah.
sounds like, yes, it sounds like as long as everyone follows it, it's great. If they don't follow it, there's not really any teeth to the law. Yeah. Okay.
Right. Yeah.
Gotcha.
This legislation has been amended, in 2024 and in 2025, and could potentially be amended again if someone wanted to take it that way. We do have the kind of ability already within the legislation for the Sexual Misconduct Survey Council to review any extra questions that the institution wants to add. So that review process already, even though it's a different area, the review process is already part of the legislation. Okay. All right, any other questions or comments?
I have a question.
Mm-hmm.
So thinking about the PII and the sort of anonymity sections, I see why you removed those like definitions that you gave there of the specific like identity categories that of course we are requiring them together. I'm wondering if there's any ability or utility in giving some examples of other types of other types of potentially identifying information that they are not required to ask that we don't want them to, like affiliation with clubs, dorms that they live in, et cetera, just to kind of frame around that. And also whether there couldn't be, like, I guess one of the questions I have is, could a school release a data set that could be that could contain potentially identifiable information as a result of like the particular context of that institution, right? If it's an institution where there are only, you know, a handful of people who identify in this one category who are like visibly identifiable as members of that category, maybe there's 12 of them. And so that's like a big enough data set that we can say like, sure, we're going to release all 12, but nevertheless, that's like 12 people on campus or whatever. And that's like fairly identifiable. I wonder if there's any examples that we could give to just sort of like offer some caution around that. Because of course they're required to take that information. And also we would probably hope that they wouldn't release these like very specific data sets.
I think I like the idea of adding a couple of examples, and I wrote down that you had written club, residence, area of study is another one that we're not required to ask, so that could be included there. There is, you know, if we do that, right, we do lose the opportunity for larger schools, for example, to say, oh, wow, we've got a problem in the engineering department. Right. So I just want to point that out if we don't allow them to collect like that area of study. So, you know, this is always the trade-off, right?
Yeah, I feel like that's why maybe not saying it's not allowed, but maybe just like offering that like little note of context or caution, and giving the example of like, it would be potentially really useful to be able to look at data for the entire engineering department. And also if the entire engineering department is 3 students, that may be something that shouldn't be released publicly, right? Like being able to kind of offer those examples so that people can make, I mean, I'm assuming everyone here, everyone statewide who is administering this is operating in good faith, and therefore that they could read those examples and say like, oh yeah, you're right. It's useful for us to see at the University of Oregon that our giant engineering department has a problem, but maybe this tiny institution that has 3 students who are matriculating in that, you know, program shouldn't be identified in that way.
Okay. So that's something that I think might be appropriate for the implementation guide. For rules, those sort of have to apply to everybody. So I don't know if we would want to put examples specifically in the rules.
That makes sense. Totally makes sense.
But we can certainly, in the next iteration of the implementation guide, we could put a couple more maybe boxes or examples of, you know, what of how to think about aggregating data and why it's important to, as you said, you know, if you've only got 12 people with this identity on campus, you know, do you want to share that information? You remember we required that folks, we again, that trade-off between losing what's happening to those 12 people, right, by merging them in with a larger group, versus the risk of their identities being exposed. So that's why we had set it at 5 for demographics, or no, sorry, was it 10 for demographics and 5 for experiences. And I think I actually wrote that into, did I write that? No, it's not in the rule.
I think you have it somewhere in the rule because I remember those numbers.
So. Yeah.
I think it makes a lot of sense that my examples are maybe better for an implementation guide than rules. So we can just kind of like pin that in our brains for next time.
Right. But I think you're right. I think that providing an example might be really useful, especially maybe for folks who are doing this. I think a lot of the folks who are actually going to be implementing the survey are not going to be people with research backgrounds, or people who have thought a lot, as you have, Martina, about about the harms that can happen to someone when they are identified without their permission.
Thank you. I think these are so thoughtful, these rules, and I'm excited to see like how this all can grow and change in its next iterations too, after we get that feedback from folks who don't administer surveys all the time, who are all of a sudden tasked with doing this huge thing.
Right. Yeah, for sure. Okay. And then the last rule, or there's two more rules here. Okay. So yeah, you're right. There we go. Protecting student anonymity. That's where we've got we're actually codifying in this rule that they have to merge their data in the way that we recommended in the implementation guide. I'll go back up to the survey response rates and then come back down to protecting student anonymity, because I actually have a question for you all in there. So the maximizing survey response rates, that's part of what the legislation requires, is that the HEC provide rules that will help maximize the survey response rates. So that's why we differentiate between response rate and completion rate. So we want to, where it says shall, they have to do that. So institutions shall determine and implement survey recruitment and dissemination practices that will encourage students to respond to the survey. We're not telling them what those practices are, but we are then suggesting that they consider the implementation guide that we provided them that has a lot of information about maximizing response rates. One of the issues that came up was, well, can we require students to respond to the survey? We want to make sure that they understand that none of the strategies that they use to increase response rates should in any way penalize a student who's not responding to the survey. Right? It's just basic consent. And then we want the response rates, which are basically, those are the response rates, are things that can be altered by the college's messaging, right? So your response rate is, did you open the survey? That's a response rate. So everybody who opened the survey, that they've responded to the survey. And so a school's messaging can encourage students to respond to that. That's something that they have a lot more control over than the completion rate. The completion rate is, I went through, I answered all the questions, and then I submitted my data. So we want to know what's the difference, how many people opened it, how many people finished it, and where, if there's a huge drop off in there, maybe there's some parts of the survey that are discouraging people from completing it, or maybe the students have some concerns, and that might be something where I'm hoping that the council in the future might actually be able to talk to some students about what their experiences of the survey were. So that's why that's different. We are asking them to obscure the information. We're asking, and this is where I kind of need your help. Student or institutions shall utilize security safeguards to ensure that survey data is protected. I was asked by folks who've reviewed this at HEC, are there any standards that you could recommend, or is there any language that you could use that would be more specific than just utilize security safeguards? So I wanted to check in with you all and see if you had any suggestions or ideas.
Martina, feel free to hop in here too. I know that our field has a lot of information around this, but it's specific to our field. So I don't know if that would be helpful. It is specific to survivors and survivors information. I can certainly look for any best practice guides or things like that, if that's helpful.
Yeah, we're held to such a strict standard by the Violence Against Women Act requirements, which certainly we can share, and also might be, like Jenna was saying, like more specific or more stringent than is like broadly security safeguards. So I would defer to somebody who does this institutionally, unlike me, who's outside of I don't know, that world.
Mm-hmm. Are there any IT standards that folks are aware of that could be used as a guide? So like industry, thinking like IT industry standards for protecting data. behind firewalls, that sort of thing? Is there a set of rules that we could refer to?
That's such a good question, and I'm wondering whether that's not something we could ask of folks on campuses who are responsible for ensuring FERPA protections. I know, for example, that some of the cloud-based platforms like Dropbox, there have been concerns about the FERPA safety there, and so there's been instructions that have been written. But again, I'm not the expert in that, so I defer to those who are.
I can,
Okay.
oh, sorry, this is Jimmy here. Sorry. I can take a look at the IRB's guidance for Oregon because I feel like most places with IRBs will give them like the minimum level of protection they need to have to get approved, but I think it's standard enough that it could probably go in a guidance like this. I just need to find the exact verbiage. But usually it's like behind, stored on a computer that has a password in a system that has, that can't be accessed certain ways. So I can look for the language, but there is probably some pretty standard guidance that we can uncover. But I'll look for it real quick and see if I can throw it in the chat.
Brilliant. Thank you, Jimmy.
Yeah, I was gonna
But-
say some. Oh, hi, this is Adea. I was gonna say some kind of IRB process because I don't know if there's a standard. I know whenever I had to go through the IRB, I have to show how I will protect, de-identify the data, how I will store the data, and show who would have access to it and state who would have access to it. That's pretty much it. It just has to be behind some kind of protection or some kind of device that only a few people or can have access to it, and you had to always explain it. I just know it was a series of questions they would ask, but I don't know if there's like a general policy. What about you, Kelly?
I missed I stepped out for a moment, missed the front half of this. I know we're talking about FERPA and protecting data, but what was the specific question?
Number 3 under protecting student anonymity, where I have the rather vague verbiage of utilize security safeguards to ensure that survey data is protected. And I was wondering if there was more specific language that folks could recommend, or if there were industry standards that we could refer to here.
So I think, maybe I could pull up that email that I sent you over the summer or the beginning of summer or something, Rowan. I think that I had sort of a stronger language there. Like I really think that only an IR person really ought to have access to the raw data. Like I think this could be defined in very narrow terms, that only the only person who should have access to raw data is the person who is, institutionally responsible for protecting, utilizing sensitive data, right? I realize that at some places that may be more than one person, but I think we can be pretty darn explicit about that. So I will go back and check. If I can, I'll try to come up with something that I think is short and brief, but that expresses that. Like it is entirely reasonable to place this demand on in the instructions here. There's just no reason for anybody beyond an IR office to have access to the raw data. Just absolutely none.
Yeah. I totally get your point, and there are a lot of schools that don't have IR
Oh,
offices.
Technicality. It's a technicality.
I know. Yeah. Yeah. So it's
I mean,
so that's yeah.
I have to say that I am a little concerned about the breadth that those who are preparing analyses and reports might be understood to mean by by people who may not, if you don't have an IR office, you may not be quite as sensitized to these things because you just don't have somebody around whose job it is to be all uptight about this, like we are. So anyway, I'll see if I can't draft something up and share it with everybody. I mean, I would encourage anybody else to do that too, but I'd be in favor of being a little more emphatic and narrowing it down a little bit. Like, for instance, saying something like, you know, should be restricted to the person whose job it is to handle, whose job it is at a given institution to handle, secure, and protect sensitive data, right? So if there isn't an IR person, there must be somebody who's charged with that kind of a responsibility. And can I?
Yeah,
Oh, go ahead,
I was-
Isaiah. Sorry.
I was just going to agree with Kelly. Usually you have to identify the type of person. It's usually some kind of restriction of the type of people who can handle that data always in an IRB. So.
And I was just going to add, I think this is just a language thing, but number 2 above it, before any release of survey results or reports, that's fine. Institutions shall de-identify and anonymize all survey micro data sets. What I'm curious, that seems to confound 2 things. Like, is that meant to imply that the IR person will de-identify and just dispose of that so that even they could never identify anyone else?
I think that is what I was thinking. What
Okay.
we've seen, and those of you who've done surveys on campus, you may, I don't know if this applies, but I know that some of the surveys that we received when I was on campus included very personal information. You know,
Right.
this person harmed me
Right.
in these ways, right? Or included other identifiable information. And there's always, you know, there's always going to be that kind of, we make it really clear this isn't the way to make a report. Don't make a report here. Don't provide, information that we can't use here. That information will come up, but the information should be removed from the database. Is what I'm positing here. Is what I'm suggesting here. If that
like permanently eliminated is, no,
Yeah.
I think that's very appropriate. I'm all in favor of that.
Okay.
I don't think there's any reason, once the data is collected.
All right. Okay. Any other comments about this?
I
I
don't know
wrote.
if you're all still there or not. I think this has happened here with this group before.
We're here. Are you?
I kick a cable and then I disappear. Am I back?
Well, we can see your face, but
Okay.
you're
Sorry about that.
frozen, so that's okay.
I think this happened in this group once before, and it hasn't happened in a while, but the cable is under my desk and I just kicked it, which caused the power to go off, which caused my computer to oscillate from the dock back to the, anyway. I'm totally down with this. I think the more restrictive, the better. There's absolutely no reason to keep identifying data once the data itself is collected, right? The email can be erased. Anything else can all be erased. Even the person processing it doesn't need it. So
Yes.
this is good. I'm all in favor.
Yeah. And I was trying to explain how to clean the data without like saying clean the data, because that if you know what that means, but not everybody necessarily would if they're not in research.
Right. Even people who've been trained often don't have any experience doing that. Like, they've heard about it and they've been shown clean data sets and told clean your data, but that's very much an experience driven skill.
Yeah. Okay. So Jimmy, I know you're looking up stuff for me. If any of you are looking up information for me and you want to send it to me, that would be absolutely great. We're still at the really initial phases with this draft, so I can make all kinds of changes. And if folks want to discuss any more of the language, if there's anything that you think should be added, I'm happy to have that conversation. Okay, so yeah, so again, if you have any comments or anything, and you know, if you have a chance to reflect on this and go, actually, I think we should put it this way, or you should add this, please feel free to send that to me. And again, please feel free to check the rules that are pending, because some of that stuff is already, some other issues related to the survey. There's a couple of things that are already in those pending rules. But other than that, I think that's all I have for you. So today, let me try to stop sharing. Let's see if I can get my computer. There we go. Yay. Okay, it worked.
Is it? Hey, Rowan, could you send us the pending rules and kind of what you want us to comment on again? I have an idea, but I think I just need it like in an email form so that when I
Sure.
get back, and start thinking about this, because I'm in the middle of federal and state reporting, so like my mind is gone. So I just need time to reflect. And I do think it's going to be just following IRB processes and things like that. There should be like some kind of IRB process because it talks specifically about storage. Now, I don't know if it's a rule. I know they ask you about it, but maybe there are some schools that actually say what the rules are explicitly.
Mm-hmm. Okay. All right. Thank you. I will email you. I will email you both the pending rules for which the comments due tomorrow, and I will email you this set of rules again. Just to be clear, you shouldn't necessarily be discussing them outside of this meeting, because that would be an issue with public meeting law. But your comments can come directly to me, and that's not going to get us in trouble. So. So I will do that. Right. The other thing, just so you know, still trying to figure out if there's any kind of a legal protection that will protect the data sets, especially those microdata, that individual, that unaggregated data. If there's any way to protect the data sets from FOIA disclosures or from possible subpoena. Having been an advocate, I am fairly paranoid. And so, you know, one of the concerns that I had was that defense attorney might subpoena the data set and go through and try to find information that was related to a specific case. If that could be narrowed down and the person had indicated that they had sought, for example, counseling, then those counseling records might be if the set can be re-identified, they might ask for counseling records. So that kind of paranoia, that level of paranoia. And obviously we don't want somebody getting a hold of the whole data sets and just publishing the raw data. So even if we keep the schools from doing that, if there's a FOIA request or a subpoena that releases that data set, there's nothing we can do to protect the data in that situation. So
Rowan,
we're trying.
may I ask?
Yeah.
Oh, sorry.
Go ahead.
How long are institutions required to keep the raw data?
They are not.
Ah, okay. So that could be one mechanism. That's one of the things that VAWA sort of gives us tools to do, is that we only keep data as long as we are required to, and we destroy it as soon as it is not required to be kept. And that makes it really easy, because you can absolutely subpoena me, and if I have nothing that I can give, then it's not useful as a subpoena anymore. So that could be one mechanism, is if there's no legal requirement to retain any data sets, that destroy them as soon as they are finished being analyzed.
Mm-hmm. I think that's a really good point, Martina. I worry that might, again, that trade-off, right? Would that impede an institution's ability to compare progress across survey years?
Yeah,
Maybe,
possible.
well, maybe it could be the only thing that is kept is the summary data, not the full data. So it's the summary data let's say the average or something for a particular question that is kept. So just data for analyzation, not the detailed full data that is kept, so that you wouldn't have any possibility for identification. So yeah, so that could, so you still can do your across year analysis and do all that, but you don't have any like vibrant information that could go into detail about the person. You know, you just have basic demographic information, like, you know, just basic stuff. So maybe we could just say you could keep the minimum. I don't know how you would spell that out, but you just only keep, after a certain time, you only keep a minimum of the data for institutional purposes,
Yeah, I
and
think
then destroy the rest.
oh, sorry, I didn't mean to cut you off. I think one of the concerns about telling institutions to like get rid of the data, I just feel like there going to be so much effort into getting the survey completed, and I do think there will want to be some tracking in populations, even small populations, and I think it might be difficult to I don't know if folks will be warm to getting rid of the data. I understand the concerns around the sensitivity of it, but I also know that like I think part of this is also measuring progress, and so you can get some of that through some of the summary data, but there's probably some really smart folks who do really cool data things that might be able to point out some trends that wouldn't be available in summary data. And also, I also think it matters if the institution's going to move through an IRB process with this, and so there's already another set of eyes on it. And so I don't think one size fits all on destroying the data, getting rid of the data, whatever. And I want to value the time and energy it took for the institution to put this out there to the students. And so I think it's a complicated concept. But I know that we would be interested in keeping data at least from one survey to another to be able to measure progress across. Because again, this will likely be our only like climate survey we do around this topic because it's such a lift and such a big opportunity for us. So.
Is it possible to just encourage a practice around, if you are deciding between keeping data that could be re-identifiable and not, to prioritize survivors' safety in that? I know that we come from a pretty far to one side spectrum, but in my view, there is no benefit that would outweigh the possibility of a survivor's information being read in court. So I don't know. It's a tough one. It's a tough one. I totally hear it, but I would just lean pretty heavily towards, defense attorneys are smart. They're good, and they know what to look for. So if there was a Title IX case and that went to criminal court, everyone's aware that this survey is out there. It's a small school, things like that could be very damaging. Where it wouldn't necessarily be that way at U of O, because it's a gigantic school, right?
Mhm. Yeah. Yeah, I think I really get what you're saying, Jenna. I think I'm not as concerned about it showing up in court, honestly, as being used as leverage for a survivor in the process. So, for example, we've seen situations where defense attorneys have hired private investigators who've gone out and talked to everybody's contacts, or there have been requests made, I want to see all of your medical records. That might not be granted in a civil court, or that might not be granted in a Title IX hearing, but the actual request itself can be seen as threatening and discouraging for survivors, right? So anything that we can do that will limit the existence of data that could be requested, I think will help protect survivors. But I totally get what Jimmy's saying. This is really expensive for schools to implement this process, and this is really valuable data. So that, again, that weighing that, what is the benefit of keeping the data for the school versus what is the risk to potential survivors who might be identified if the data sets are not aggregated.
And Rowan, is there clarity on what actually is discoverable through the FOIA process from the survey? I guess I've just never experienced a request where we've had to turn over the raw data. We've only had to turn over like results. And so I'm curious to know, could it be compelled in court to actually get the raw data? Um, I I just I just haven't had that experience, and so that might be the case. And so I want to make sure that, yeah, I think I hear the concern about survivors and, putting in data and making sure that we protect that information, protect the survivors. But we're also institutions that also hold confidential information anyways. So we have lots of information that could be reportable, but a lot of that has to be de-identified before we give it to somebody. And so I'm just curious to know, like, from your perspective or experience, I don't know if other states who've done this, if they've run into that concern, or if it is a concern, what do we have to report if we're asked for public records?
So where this gets really, so I'm not an attorney and I can't legally, I can't make any sort of that, but this data is not protected by FERPA, right? Because it's not linked to the student record. And so when you're talking about some of the disclosures, the data sets, a lot of the data sets that the public universities have are already protected by FERPA. And so they would have to go through FERPA before they were released, right? There's nothing that I'm aware of right now that protects this data set in the way that FERPA or HIPAA might protect it from a FOIA request. Or from subpoena. I don't know if I think consulting the Victim Rights Law Center might be something to do. I think we also talking to the Attorney General of the Attorney General's office in Oregon might be, getting more clarity from them might be helpful too. And I also wonder if this is one of those things that might ultimately need a legislative fix, right? The advocate confidentiality is protected by legislation, and maybe there's a way to make this sexual misconduct survey data protected by legislation as well.
I think those are great things for us to think about for next steps then. In particular, a legislative fix would definitely be the easiest and cleanest thing, just make it protected. But if not, then asking the AG or asking VRLC could be useful just for gathering more info.
Hey, Rain, I see your hand.
Hi there. So sorry. First of all, just wanted to apologize for leaving and rejoining so often. The video has not been working, so I'm on the phone as well. But wanted to ask about timeline for if this is something that needs a legislative fix, about how long we think that would take, and sort of which seems the best option in terms of timeline. Yeah.
I don't really feel qualified to, I don't, I'm hoping to be able to have conversations with legislators maybe later this year, and might be something to suggest. Generally speaking, in Oregon, the amendments that to existing laws. Most of them happen in our biennial, in our big session years. Some of them can happen, some minor adjustments can happen in off years. What we've got coming up in the next legislative session is one of those off years. So it might be possible to, for something to go to the legislature this spring and potentially be implemented or be approved on an emergency basis as early as next summer. But I can't promise I can't promise anything. I'm way out of my comfort zone and probably shouldn't even be talking about this right now.
Totally. Thank you. Yeah, I was wondering about, because I know we were hoping to get these administrative rules out in early 2026. And so that seems like a really sort of long timeline.
Great. And I see Shrestha, and I'm so sorry, I'm going to totally butcher your name, Shrestha.
Yeah, could be. Hi, I'm here from Representative Hartman's office. So just to give some clarity on what a legislative fix could look like. Next year is one of those short sessions, as Rowan mentioned. So every legislator only gets 2 bills. And given where we are, it's because it's end of September now. I think, unfortunately, a lot of legislators already have their 2 bills spoken for. So there may be a chance that there are some legislators who have some flexibility, but I do think a lot of legislators have already been working through the 2 bills that they're planning on to propose next year. So it might need to be a long session fix the following year after that. But again, there is a chance. From several conversations I've had, many legislators have already been working on their 2 bill concepts. So yeah.
Okay, Kovian. So thank you so much. That's incredibly helpful. Really appreciate that.
Thank you for answering my questions. I'm a college student still learning about all these legal proceedings.
Jennifer, I think I had seen your hand. Did you?
Nope, I think Shrestha addressed it. That's what I was going to bring up. So.
I just want to thank you all. I learn so much every time I get together with you. I really appreciate that. I've made some notes. I had copied down, Jimmy, what you had given in terms of federal guidance on climate surveys. I appreciate that. That's from that. Is that the link, the Justice Department link that you provided? Yes. Okay. Thank you. Okay. Yeah, that was back in the days. Okay. Thank you, Jennifer. Does anyone else have any last comments or anything? Please remember, email me questions or email me comments or information. Really appreciate that. And hi, Rain, I see you again.
Sorry, no, you answered my question right as I was going to ask it. I was just asking if there were any action items that we could help out with, but yeah, it seems like just emailing any more information. Yeah.
I'll follow up with that email with the rules, the ones that are pending, and then this draft again too. So I think that's all I've got, and so I will turn it back over to Martina.
Excellent, thank you. Well, that's all of our agenda. So unless there is any other news or updates or information that we need, we can end this meeting. So I'll pause for a moment and see if there is.
Yeah, I did just want to joke and say, Rain, your #1 action item is to have every single one of your friends and their boyfriends and best friends and cousins and dentists take the survey. Totally joking. But I actually thought that this committee would find this helpful or insightful in any way. Every Voice recently just did a big analysis of 2023 Clery and VAWA data, tracking the big 5 categories of rape, fondling, dating violence, domestic violence, and stalking. It is fascinating. I think, it kind of speaks to what we already know, that like this formal reporting process is not working for a lot of student survivors, and that this data doesn't really answer any of our questions, but maybe just like creates new ones. So we did give a little shout out to the annual reporting requirement in Oregon, as well as the survey. So if you wanted to take a look and just kind of get a sense of what's happening nationally, I would recommend. I'm really, 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 really excited about this survey. I am so confident that it's going to keep pushing Oregon in the front in terms of this sort of data transparency and having real actionable, tangible data we can do something with. So just wanted to share this with my fellow policy and data nerds in case you need some light reading this afternoon. But thank you all just for your ongoing commitment on this and being willing to open the can of worms that is the legislature and doing legislative fix as needed.
Wonderful. Well, now we all have our fun light afternoon reading. And unless there's anything else, we can adjourn the meeting. Nothing else? Okay, in that case, this meeting is adjourned. Thank you all so much.